About 2 seconds. Great. Welcome everybody to the Senate Democratic Caucus for today is Tuesday, January 30th. I don't know how it got to be January 30th so fast. Welcome. It's good to have you today. We are going to be voting on a proposal to amend the Constitution. It's called Prop 1. We have discussed it before in this caucus, and would like to address a number of questions have come up and concerns that we would like to address head on today. I'd just like to say overarchingly, we operate in many ways in this building on a system of trust and expectation that the committees of jurisdiction will do the work necessary before they bring something to the body. The committee of jurisdiction in this case has done a huge amount of work on this proposal, and it is ready for prime time. And so I would remind us all, we function in large measure needing to trust the time, effort, and experience of that committee's work. So I would just like to say that at the beginning of this, and then we have invited Senator Hardy to continue her work presenting this to us, and then we're going to invite the two co-chairs of the House, the special committee on the impeachment process from the House, who have the lived experience of what it's like to try and address impeachment at the moment, what their constraints are, what their challenges are, how it has worked, how it hasn't worked, because that in large measure is what we're in part addressing in this proposal. So I think without further ado, Senator Ruth Hardy.
Thank you, Senator Clarkson. I've talked to many of you. I've sent out a lot of information to the caucus. So I'll just do a quick recap and then try to answer any questions, but then turn it over to Representative Lalonde, who can really dig into with you about what the impeachment process is like and why it's problematic and why we're trying to find another remedy with this constitutional amendment. The constitutional amendment, as I've talked about before in this caucus, would make the ability for the legislature to set qualifications for the election to and holding of county offices. That's the sheriff, the state's attorneys, the probate judges, and the assistant judges. That provision is already in the Constitution for probate judges and has been for 30 plus years. And the language that we used for the other three positions mirrors exactly the language that's already in the Constitution for probate judges regarding qualifications. Then there is an added provision for all four offices that the legislature could establish a process for removal of those officials if they do not meet the qualifications. So that's the basic core of the constitutional amendment. The other small provision in the constitutional amendment is actually cleanup of the Constitution, so to speak. In 1974, there were a series of constitutional amendments that amended the Constitution, mostly surrounding our judicial system. And one of the things that 74 constitutional amendment did was remove the office of the high bailiff from the Constitution. There were 4 mentions of the high bailiff in the Constitution. The 74 amendment removed 3 of them and missed 1 of them. So it appears in a sort of summary title in the Constitution, but the chief counsel of the Legislative Council and I did a lot of archival research at the state archives to sort of figure out what happened with the high bailiff. So this would remove the 1 mention of the high bailiff in the Constitution to be consistent with the intent of the 1974 amendment. There's a lot of information that points to that the intent was to remove the high bailiff at that time. So that's why it does that. The high bailiff would continue to exist in statute as long as we wanted it to, similar to the Attorney General, which is not a constitutional office, but does exist in statute. So that's the high bailiff. The other things, I think there's been some concern expressed about how the language is vague and there's not a definition for what qualifications are. The Constitution is meant to be an overarching document that sets out the structure of our government and the values of the government and the citizens of Vermont. It is not meant to be specific. Our statutes are meant to be more specific. So we cannot put in the statutes any details until we change the Constitution that gives us the authority to lay out what the qualifications would be. But for a probate judge, which is the only one that already has the qualifications, it is required in statute that a probate judge be allowed to practice law by the Vermont Supreme Court. So that's what we're talking about as a qualification, a specific objective qualification that is specific to the type of position, not some random qualification. And it also would have to be consistent with non-discrimination law and the US Constitution. So we couldn't have something that discriminated. So for example, someone said, what if we said only men can be sheriffs? That would be a violation of the US Constitution and would not fly. So these are job-specific, profession-specific, objective qualifications, and we have precedent with the probate judge. So that's why we don't get into the specifics of it in the Constitution. And we spend a lot of time talking with people and debating this amongst the committee. And the constitutional amendment was introduced by Senator Sears and I, and all the members of the Judiciary and Government Operations Committee, plus Senator Lyons, are co-sponsors of the initiative. And it's been a year. We've been working on it for a year. So I'm happy to take questions, but I also would really want to make sure we get time to hear from Representative Lalonde. So if there's a Senator Bray.
Non-discrimination, et cetera, specifications that were sort of performance-based, et cetera. But how do you know that that is how qualifications will be specified by a future legislature? I mean, I understand your desire to see such specifications written, but there's no language in the proposal. Is it not correct to say there's no language in the proposal that limits qualifications to the sort that you're specifying, that you're sharing with us now?
So I don't have a crystal ball. I don't know what a future legislature might do, and we cannot bind a future legislature in the language that we can't require them, and we certainly don't want to. It wouldn't be appropriate to put the details in the Constitution. I'm merely saying that we have precedent with one of the 4 positions that the requirements would be job specific. And we also, whatever we put in, or a future we puts into the statutes, would go through the full legislative process, would be introduced as a bill, it would be debated by committee, there would be testimony, presumably there would be testimony from the 4 professions themselves, and also the oversight bodies of those 4 professions. For example, the Vermont Criminal Justice Council, or the Judicial Conduct Board. So those are agencies and organizations and groups that presumably a future legislature would hear from when they are setting qualifications. I cannot make a guarantee, but what I can say is that we can't set the qualifications until we change the Constitution, and we can't change the Constitution until we pass it in the Senate. So there's an order to how things have to happen before we can get to that level of detail. All right, unless there's another question, I'm going to turn it over to Representative Lalonde.
So, Representative Martin Lalonde and Mike McCarthy, and then anything that we might want to add, we have also our chair.
Great. Thank you.
Martin, welcome. It's good to have you.
Yeah, thank you. I'm delighted to be here. So I'm here in my capacity as the chair of the Committee on Impeachment Inquiry. I have my backup Vice Chair Michael McCarthy of that committee as well. So I want to give you a little background of what we did, and then I want to give you our perspective, having lived with this since last June, or actually May. Let me just talk a little bit about what our first impeachment inquiry was with respect to State's Attorney Lavoie. And we started in May on that particular impeachment inquiry. We had testimony under oath of 31 witnesses and 13 meetings throughout the summer. So it was pretty significant time commitment, pretty significant work that we had to do. It was fairly egregious behavior, though in the end, we did not have articles of impeachment because State's Attorney Lavoie, I think, did the wise thing for Franklin County and resigned. If we had gone to the articles of impeachment, we would have done that probably in the October timeframe. And then it probably would have been 2 months of trial preparation by the defense and by whatever the team would have been for us. And we would have likely have we would definitely hired attorneys to help us out on that, and it would have become a fairly costly endeavor. After that, probably we would be talking about a week or 2 week trial in the Senate. And I think at the time we were looking at trying to bring you all back in December for that. But again, luckily, Lavoie did the right thing and resigned. So we moved on after that to Sheriff Grismore. That's all right. So with respect to, well, first of all, one other point. The behavior we were dealing with State's Attorney Lavoie was fairly egregious and occurred when after he'd taken the oath of office. He was in office. So starting with Sheriff Grismore, we are looking at behavior that occurred before he took office. And what we have found out is that there is precedent in other states that have had impeachment inquiries, that have had articles of impeachment and even impeachment, the trial, based on behavior that occurred before the person took office. And that has been found to be reversible, that was not allowed. You can't base, this is what our legislative council has told us. This is what case law that has looked at this has found, is that you can't impeach somebody solely on behavior before they took office. What you look for is a pattern of behavior and what has that behavior perhaps led to in office. And that was a big part of what our inquiry has been in that case. So the other thing is that we're finding is that, well, let me back up. So we definitely had good testimony that would really strongly support that you want your sheriffs to be certified law enforcement officers. Preferably a level 3 certified officer from talking to other sheriffs and deputy sheriffs and other testimony we received. When the certification was lost by Sheriff Grismore, at least at this point, we feel that that's not a basis in and of itself for impeaching him, because there's nothing in the Constitution that allows that to be a criteria. And without having that criteria allowed through this constitutional amendment, that's not a basis. And yet, everybody we were hearing from is that it's really important to have certification, have a law enforcement officer as the sheriff. So we're not done with that work yet, but we really can't impeach a person for having lost his certification. Just like if Lavoie had lost his bar license based on behavior that occurred before, maybe if he lost his bar license based on behavior while he was in office, that underlying behavior we could get at, just like we could perhaps get at underlying behavior, but you can't have, those aren't requirements. Those aren't requirements, and that's what's really troublesome for both state's attorneys and for sheriffs, of not being able to have that requirement on which to base their behavior against. So in any event, it's been pretty arduous, and that's the other component of this, is that it's not a straightforward process. It takes a lot of time. I can't imagine if we had to be doing this during the session when we have so many important issues that we're having to take up, or taking up your time for 2 weeks of trial, although I really was hoping to get a chance to have a trial in front of you all, but maybe some other day. In any event, I'll see if I've missed any other points that Representative McCarthy would like to add.
Oh, we've got All right, great. Well, thank you for having me. I know it's unusual to have House chairs at a Senate caucus, but this is a particularly unusual moment in our history. So I represent St. Albans City, and Franklin County right now is in an interesting position of having a sheriff who has been decertified for professional misconduct by the Vermont Criminal Justice Council. And as Representative Lalonde said, that does not in and of itself remove Sheriff Grismore from his position as the elected sheriff. The case law from other states that Representative Lalonde talked about, I just want to make it really clear. It is very difficult to imagine us advancing articles of impeachment when the behavior happened prior to somebody taking the oath of office. And so even though, especially the testimony and the evidence we saw on December 11th points to some financial mismanagement, like tens of thousands of dollars in retirement funds that should have gone into state pensions being paid by then Captain Grismore to himself, I mean, some pretty egregious behavior. Those things happened prior to him taking the oath of office, and impeachment is a political tool that we have as a remedy. The remedies that have usually allowed us to kind of get past this and move forward when there's been criminal acts by several sheriffs throughout our history. You know, I think about a Windham County sheriff who resigned as part of a plea deal, right? So resignation is a way to create that vacancy and move forward with a new person. We don't have that as an option here. In this case where even in the face of decertification, an elected official is using the fact that they were elected for a 4-year term, even despite of having their professional certification removed for cause, and in spite of everything that's come to light, and the editor of the newspaper and former law enforcement and his fellow sheriffs asking him to resign is saying, nah, nope, the voters voted me in. I'm going to sit here. I'm going to do this job from a desk, you know, without the ability to carry a gun and perform law enforcement duties. But I'm going to defy that, and I'm going to defy all of these calls. And I was elected. I think that my constituents in Franklin County can't believe that we don't already have this kind of a mechanism or the power to even debate one. And so what Senator Hardy's great work in Senate GovOps did was to say, hey, the General Assembly should be able to set some of these qualifications. And one other thing I wanted to add to what Representative Lalonde said was that we don't even have the ability right now, if somebody is charged with a really serious crime while they're in office, there's no mechanism to suspend them. So giving us the power to set qualifications could also allow us constitutionally, I think, to get at what happens in that time, even if we are going to use impeachment as a remedy to remove somebody from office. That's a months-long process in the best of circumstances. What do we do in between then if that person is really a problem and unfit to serve and they're going through a criminal process? Everyone's entitled to due process, but we should at least have the ability to, under certain circumstances, suspend somebody from their office if they're found to be indicted for a crime, for instance. That's a qualification that we should put on holding that office. So those are just some of the things that I think about when I think about why we need this amendment.
And I just want to add one important fact is that the financial issues, that wasn't known by the voters. That came out after the vote. Yes, people had the opportunity to see the use of excessive force, but there are other things that were not before voters as well that should disqualify him from being in office, but we don't have a way to do that effectively because it happened before he took office.
Questions, and I know that there's some other questions that have come to light in other meetings. But Beck, why don't you start?
Thanks.
Yeah, I think.
One of the questions that's come up, and as elected officials ourselves, I think it's relevant. How do we currently treat other countywide elected officials like senators, like representatives, and why would this be something that we would do specifically for this other group of people? I know we've talked about it in committee.
Yes, we talked about this in committee. So legislators, there's a process for removing legislators. Legislators is called expulsion. That is specific to the legislature. We sort of police ourselves as an internal body. There are 180 of us. and we are diluted by the fact that there are 180 of us. A sheriff runs their whole law enforcement agency for a county and is in charge of that law enforcement agency. For other for any other elected officials, the remedy, it's called the exclusive remedy, and we talked about this at length, Senator White and the committee, is impeachment. So there is not another remedy for removing other elected officials. But the committee was specifically focused on county officials because of the issues we've seen with sheriffs and, frankly, other county officials, state's attorneys, which is what Lavoie was. We just recently had an issue with a state's attorney in my county, and probate judges. There was a serious incident in Caledonia County where a probate judge refused to resign, and the judiciary was forced to move judges around in order to cover his cases. And then assistant judges. There have been issues with assistant judges in many counties. Again, unless they resign, there's not a way to get them out of office. And just a note to the point that one of you guys made, I think Representative Lalonde, when there's somebody who is who has been arrested for criminal activity, while that trial is happening, there's no way to suspend the person. So we in Addison County had a sheriff for a whole year that was accused of sexually assaulting a woman while he was acting as sheriff. And he spent the entire year harassing her and many of the people that she worked with while he was sheriff, and we could not remove him from office.
Did you consider doing a recall instead of something else? And why did the committee choose not to change the Constitution to allow recall?
Yeah. So this is a common question I've gotten about recall. Recall also would require a constitutional amendment. It is, as I said before, the exclusive remedy in the state constitution is impeachment. A recall there was a provision in an earlier version of the state constitution that allowed for voter recall, and that was removed. And there is evidence that the founders did not feel like that was something that they felt the voters should be able to do, that it was the job of the legislature only to remove somebody from office through impeachment. So the concept of voter recall came up, but it would also require a constitutional amendment and didn't seem consistent with our Constitution. The other thing is voter recall, as we've seen in other states, tends to be really political. So somebody can do a voter recall just because they don't like somebody from the other party, and it's used as a political tool, as is impeachment, as we're seeing right now at the federal level, used as a political tool. And what the committee really wanted to avoid was having it be a political decision and really much more focused on a job qualification decision. So that's why we went with this option.
Christopher.
Thank you. Thanks for coming down and sharing like frontline experiences. So impeachment is the tool we have in our toolbox right now to deal with this. And I don't know if we've had it for 247 years or just some portion of 247 years. Why not? And if it's arduous, I mean, part of me says, but it should be very arduous to remove someone from elected office. So that doesn't seem inappropriate to me. Why are we not considering improving the impeachment process? Like if you have a tool, tune it up, make it more effective, rather than leave this tool maybe sort of orphaned. I don't know what purpose it would serve, and create another pathway. So,
right. No, thanks for that question. So the thing is that we could define the impeachment process any way we really wanted to, as long as we were paying attention to due process concerns. So there's a lot of leeway to determine what to impeach somebody for and the process for that. But still should be a very high standard. And there are case precedent outside of the state that says not for election or taking office behavior. So they're already, I mean, there's already a lot of flexibility and ability to do that. And certainly we've looked at our process, and the Legislative Council kind of evaluating, well, how did this go? And yeah, it's just it's just a long process. You have to, I mean, we have to make calls. Do we have to see 31 witnesses? Yeah, I think we really needed to hear from all different perspectives because we were getting conflicting information. So whoever's an appropriate witness probably should be spoken to. So the point is, but the main point is that we could define it any way really we wanted within the confines of what due process is. And I do understand that John Bloomer was working on whatever it would be as a trial. And that is an arduous kind of process, but there's, again, a lot of flexibility. So I don't think that that's the answer. Impeachment is what it is as far as it's going, it will continue. I mean, it's not something you can expedite, I guess, is the bottom line. I don't see how we could do that, having lived this for the last several months. Right. So the pressures are.
So, Senator Bray, something I've said several times during my committee's review of S-17 and during the impeachment process for both of these county elected officials is that we shouldn't rely so heavily as a state on the good character of the people who are elected to these offices. We should have objective ways to make sure that we're protecting the interests of the public. And you're right, in the case of Mr. Lavoie, after months of very difficult testimony and an extremely embarrassing, even the redacted version that was made public, there was a resignation, and that resolved that for the purposes of the Special Committee on Impeachment inquiry. But you've got the proof of the opposite circumstance with Sheriff Grismore. And, you know, he sat before our committee and, you know, he questioned everything that we'd done. He said it was partisan, even though we've done, you know, we have a tripartisan 7-person committee that's reviewing the work. The committee hasn't, you know, put forward any articles or made any decisions yet. And, you know, he's in a position to defend himself and he's got every right to do that. But the defiance of the process with the Criminal Justice Council and the defiance of our impeachment committee's legitimacy is being questioned by this county official. And he's in a position to do that and just be in that office for the next 3 years in spite of everything that's happened because of the somewhat unique situation that these county officials have in the Constitution, where, you know, even we have qualifications for office. You know, we went through a whole process, although we elect the Adjutant General who's in charge of the National Guard, to set a process forth for qualifications for who could seek and hold that office. And I think this General Assembly would do well to be able to have the debate and set a clear standard and not just do a political one-off every time we have somebody who, you know, has behavior that the public finds really questionable. And these deeply, deeply flawed people that at certain times, several times now in our history, have been elected to these county offices, and then it's almost impossible to remove them. And impeachment, it's not only arduous, it's just a tool that's not built to the task, and it shouldn't be. It shouldn't be easy for us to impeach people, but there should be a clear standard when somebody's lost their certification, when they've lost the ability, if they're an attorney, to actually go to court and, you know, be admitted to the bar. Those are objective, reasonable things that we should be able, as the General Assembly, to set a standards for who holds these offices. And right now, it's the lack of those qualifications being allowed by the Constitution just ties both hands behind our back. And I think we should trust the future legislature to be able to set some reasonable qualifications.
Thank you. I hope that was quite a well-done explanation. I'm not usually in the House during debates, so I didn't realize how well they can do. So, at any rate, no, that's fine. I just want to be brief and let you know that what led me to be a co-sponsor of this proposal was our absolute frustration when Senator Hardy and I tried to put together a sheriff's accountability bill. We've had so many sheriffs in this state who, if they were police officers or deputies or state troopers, would have been suspended. The sheriff can't be suspended based on their behavior. We've also had a number of cases where assistant judges have taken money and done things that are inappropriate. We've had cases with other state's attorneys who have had problems, but those aren't as magnified as a law enforcement officer who is supposed to be protecting the people of this state and his county or her county, who may have and alleged to have committed an act, and any other law enforcement officer in the state would be suspended, and you can't. You can't because the Constitution protects that. That's really what I was looking at for, and Senator Hardy as well. Additionally, I'll add that my only experience with county elected officials was during a debate on the issue of probate judges. Back sometime in the 1990s, there was a constitutional amendment that put probate judges in a different category, allowed the legislature to deal with. Then came, and I don't remember the year, but I believe Peter Welsh was pro tem. And we were doing a judicial reorganization. And there was a push afoot to require probate judges to be attorneys. But there were a number of probate judges who weren't attorneys. So the legislature dealt with that in their usual way by grandfathering or grandmothering all those probate judges. Additionally, there was an effort to provide a residency requirement. But then we heard from little old Essex County. I think there were 4 lawyers at the time in Essex County. None of them had a desire to be probate judge, and you would have had a huge problem in Essex County. So the legislature decided not to put a residency requirement. And those are the things that we as legislators do. And if we can't trust future legislators to act in a responsible manner, that says a lot about us. Well, thank you.
Yes, thank you, Dave. Any closing questions? We have time for an additional question.
It's not a question. I just wanted to reinforce something that you should theoretically be seeing in front of you. So our government operations chair, our chair of judiciary, put this together. Government operations has worked for a year on it. It has the enthusiastic support of our colleagues in the House who have also studied these issues. I will say from my point of view as pro tem, in waiting for potential references from the House, I've had to spend a large number of hours figuring out what it would look like in the Senate. So in the off session, Secretary Bloomer and I were working on that. I was delighted that one of those cases went away. It's my hope that we won't be receiving the other for a 2-week trial in the Senate, but it would be tens, if not hundreds of hours of work to do that. I think in the case such as we're seeing in Franklin, but also the non-resident sheriff in another part of the state, there are some things that if someone can't operate a weapon, if they can't conduct law enforcement activities themselves, in my opinion, they should not be a sheriff. The only way to do that is to amend the Constitution. What has come before us is a very well-crafted proposal to do that. So I would just ask folks, if you feel that you've dug in your heels on this question and you're a no, I would ask you, how many hours have you done? How much research have you done? Or is that based on a single phone call? Is it based on something said to you in the hall? Is it based on a single piece of information that someone handed to you? We're talking about a vast effort that has reached this conclusion. It's my solid hope that the Senate will forward it and that we'll begin this process, which is multi-year and ultimately is going to go to the voters anyway. But I think it would be a crying shame, given the nature of the problem that we've all seen again and again and again, if we let this stop at the beginning point. So I'll just offer that.
Thank you. Any other questions while we have the two co-chairs of the impeachment work, impeachment, Christopher?
I'll forward a question I've asked myself, and I've heard other people ask. When we add qualifications for election or staying in office, are we in some way second guessing the voters' choice to elect people who, for instance, might not have passed the bar, but they think they're reputable citizens, so they say, this is a person I trust and I want to elect that person. So I'm just trying to understand the degree to which we're taking something away from voters who have, for centuries, elected people. Sometimes we see problems with that person that's elected. Obviously, you're dealing with that now. But we are, when a voter knows, for instance, that someone's committed an act of violence against a prisoner, I don't know what the charge is, unnecessary use of force, maybe, but they vote for them anyway. It feels awkward to me to then tell those voters, in essence, that you may have put that person in knowing that about that candidate, but we're now going to override that vote by removing them.
So I'm going to answer that because the chair of the Government Operations Committee oversees voting and elections. This was something that we discussed in our committee. There is a provision in the Constitution that, and I can dig it out to get the exact language, but it is that allows the General Assembly to regulate elections and allows the Constitution to regulate elections. So the Constitution itself allows for the regulation of elections within the document, and then provides that authority to the General Assembly to do more specific regulation of elections. So in talking to our council and looking at the construction of the Constitution and the regulation of elections, this type of regulation of elections as embedded in the Constitution would be consistent with both the values and the construction of the Constitution. I addressed this in one of the things that I sent out to everybody much more articulately than I'm doing it right now. But we also heard from the Secretary of State's office, which oversees elections, and she had no problem with the amendment and said that it was very workable from an elections process perspective. And so we didn't get any red flags related to the elections process or voter rights. And in fact, it is consistent with what the Constitution already says and the powers of the General Assembly in the Constitution.
Do you want to address this? Okay. We have 4 more minutes, Mike.
Yeah, and I have to get to committee too. So I just wanted to add that we're in a position where we're trying to say in the future, we should set some objective standards. We should have the General Assembly set some objective standards so that we don't have to get into the business of when these things happen, have the General Assembly going through this arduous impeachment process in order to deal with this. And I think we should trust ourselves to set qualifications that the public is, we're answerable to our constituents. The General Assembly is the one setting the qualifications. To me, that's us trusting the voters, to trust us to do this good work rather than having it be on a case-by-case basis.
Thank you. Unless there's another Martine? Question on when we might expect a vote?
We'll be looking to vote count today and into tomorrow morning with the idea probably that we would vote on Thursday.
Okay, thank you. So you could expect us to come and ask you how you're, where you are at the moment. Martin and Mike, thank you very much Dick and Ruth, thank you very much. This was helpful, I hope, and informing. And please be in touch with Martin, Mike, or Ruth